Hello, everybody, and welcome to our Inherent Jurisdiction and Serious Medical Treatment webinar. For those of you that don't know me, I'm Francesca Gardner, a member of the Public Law and Court of Protection team here at 39. I'm joined tonight by Arianna Kelly, who's also in our team, and at the last minute, our wonderful colleague, Rachel Sullivan, has joined to assist, we hope, in a Q&A session at the end of the seminar. I start with a little bit of disappointing news. We were hoping to have Parashal Patel joining us this evening. He was leading counsel in one of the cases that we're going to talk to you about. But entirely on point, Parashal is in court as we speak on an emergency treatment case. So it shows, as you all know, these cases really do happen and they arise in emergency situations. So he can't join us tonight, but Arianna and I were both junior counsel in the case that we're going to talk to you about. So we'd like to think we're well placed to take you through the case, its implications, and then hopefully some practice points that we can all take away from the Court of Appeal judgment. The plan, should we stick to it, is that we'll talk about the Court of Appeal case in general, which for those of you that don't know about it or are aware of it but aren't too sure exactly what the case is all about, it involved two appeals that were joined, brought by two young people, and the appeals were against orders made at first instance by judges of the Family Division, in which both cases it was declared under the inherent jurisdiction that although the young people concerned were competent, or for the purposes of this talk, if we say capacitous, to decide whether to consent to or refuse medical treatment, both in the form of blood transfusions or blood products, it would nevertheless be lawful for their doctors to administer blood to them in the course of an operation if that became necessary to prevent serious injury or death. So you will hear that whilst both cases were heard together, both involved similar principles and issues, the facts were actually quite different. And the nuances and the differences in the facts will hopefully lead to quite an interesting discussion about the circumstances in which these cases need to come to court, emergency situations, and when applications need to be made, even where there's a very remote chance of a risk materialising. So we'll talk through the facts in E's case, where Arianna represented the Health Trust. I'll then talk through the facts in F's case, where again, I represented the Health Trust, the decision of the Court of Appeal and the grounds of appeal, so the issues that the court was looking at. Circumstances arising that where there is an emergency treatment requirement. So in both of these cases, there was an emergency treatment requirement, but in completely different ways. And we hope to really talk in relation to that. And then hopefully open up to a discussion. So if throughout the talk you have any questions, we might try and answer them as we go along, but the plan really is to answer them at the end. So please feel free to use the Q&A function and we can have a discussion at the end. So if I can hand over to Arianna to take us through the facts in the case of E.
Hello, I'm Arianna Kelly. As Francesca mentioned, I was counsel in the first instance in the case of E for the Health Trust in that matter. And I was led by Victoria Butler Cole, QC, in the Court of Appeal on it. So just starting off with the facts in E's case, E was 16 years and 8 months old. There was no question that she lacked the capacity to make her own decisions. She clearly understood the nature of her illness and the risks of surgery and was a very bright young woman. E and her family were all very committed members of the Jehovah's Witness faith. She had gone through various religious ceremonies. It was very clear that these were her own views rather than those of her family's. And she had prepared a written statement expressing her refusal of blood products under any circumstances, even if that was a life-threatening situation. And this predated the incidents that arose in these cases by some time. Unfortunately, in May of 2021, E experienced an episode of appendicitis. She had attended at a hospital on a Sunday where she was investigated but told that she did not have appendicitis. She then continued to be in quite a bit of pain. And when she returned to the hospital on Monday, she was scanned and she was told that she did have appendicitis and she would need urgent surgery to remove her appendix. There were three potential stages of this procedure. First, she would have a diagnostic laparoscopy in which there would be a camera inserted to explore what the findings were inside her abdomen, confirm the diagnosis of appendicitis, and see if there was anything else that needed to be treated. If this confirmed the diagnosis of appendicitis, she would have a laparoscopic appendicectomy. If it was not possible to undertake this by means of a laparoscopic appendicectomy or keyhole surgery, she would have to convert to an open procedure in order to get her appendix out. Each of these procedures carried with it some risk of a bleed. The exact risk could only really be determined once the surgery had begun, as it was possible there could have been additional findings on the diagnostic laparoscopy. The open procedure carried with it significantly more risk if it was needed, but as noted, they would start with looking at a laparoscopic appendicectomy first, which would have a lower risk of a bleed. However, it is possible that even though the risk of this happening was small, quite a severe bleed could occur during the course of the surgery. In some of the evidence explored before it was filed for the Court of Appeal, it was noted by the experts that it's not always possible to determine how severe a bleed will be when it actually starts. The hemorrhage might come on quite quickly, and it could require action to be taken almost immediately to prevent a serious risk of harm to E in that situation. E consented to having an appendicectomy. She was quite happy to have the treatment for her appendicitis, but she was entirely opposed to the possibility of using blood products under any circumstances. On the Monday on which she had been diagnosed, she discussed the possibilities of treatment with her family, being supported by her father, and a member of the Jehovah's Witness Liaison Committee, and they discussed this at some length with the anesthetist who was responsible for her care. They described the chances of her having a severe bleeding as being quite remote, and they estimated on the basis of literature review that it was going to be somewhere between 1 in 1,000 and 1 in 2,000 that she could have a bleed that was so severe that it would require a blood transfusion. But this was acknowledged to be a very rough estimate on the basis of the facts, and again, it would be something of a dynamic risk depending on what actually happened once the surgery started. E-surgery was not able to proceed on the Monday for two reasons. One, another patient's surgery had run long, so there was no possibility of her starting until very late at night. And in any event, the clinicians were trying to clarify the position in relation to transfusion. E had been kept nil by mouth, and she was on IV fluids. She was being treated and monitored and receiving pain relief during this time, but obviously having an ongoing episode of appendicitis, she would have been quite uncomfortable. A competing concern of the clinicians was that a delay in the procedure could lead to a greater risk of E's appendix rupturing, which would lead to an increased risk of infection for her. The doctors in the case had to consider how long it would be safe to wait and determined that if judgment had not been obtained by 5 p.m. on the Tuesday, the surgery should proceed in any event in view of the competing risks of the condition itself, as opposed to the risk of relatively unlikely risk of a bleed happening during surgery, which required a blood transfusion. The trust made the application on a Tuesday morning. It took a neutral view in relation to it, but considered that the consequences of these decisions were sufficiently serious that the matter should be heard before the court. It was heard at approximately 2 o'clock in the afternoon before Mrs. Justice Theis. E attended the hearing remotely and was supported by her father. Kafkas also appeared at the hearing and spoke with her privately at some length. Kafkas set out her views, but took the view on behalf of the guardian, proposed that they supported the trust making the order. E was invited to put questions to the doctor giving evidence, and her own very clear objection to this treatment and lack of consent to it was very clearly before the court. In the trust's own evidence, it stressed that it would seek to avoid transfusing E if at all possible and outline the steps which would be taken to avoid a transfusion. There was a short hearing, and Mrs. Justice Theis gave judgment just prior to 4 p.m. that day. In her judgment, the court noted E's clear lack of consent to this procedure and the competing considerations, but found that it was in E's best interest to be treated with blood products in the event of a bleed if it was clinically indicated in the opinion of the relevant treating clinicians caring for her due to significant blood loss during or subsequent to the planned appendicectomy. Happily, the surgery proceeded about an hour later without any complications. There was no need for her to receive any blood products, and she was discharged home the next day with no further issues in that case. So that in outline were the facts of E's case, and it was appealed a few weeks later. I'll now hand back to Francesca to describe what happened in F's case.
At the time of the hearing, at the time the decision was made by the judge sitting in the family division, it was Mrs. Justice Judd who heard the application. F was 17 years old and 5 months. He had lost control of his motorbike on a bend, and he'd come off into a field, and he'd sustained quite serious injuries. He was admitted to hospital and then transferred to another hospital where there was more specialist treatment available. And 2 CT scans revealed grade 3 lacerations involving 1/4 to 1/3 of his spleen. His injury was of moderate severity, and for the remainder of his whole time in hospital, he remained stable. But with the particular type of injury that he had, there was a risk that either there would be a primary bleed immediately after or in a very short window after the accident, or a secondary bleed, which could have catastrophic consequence. And what was rather unusual in this case was that there was an acceptance by the first instance judge and in the Court of Appeal that this case was urgent, yet F was in a stable condition. He was being treated conservatively. There wasn't a treatment plan as such, but there was this remote risk that if a bleed took place or were to happen, then treatment would be required. In terms of the primary bleed, the window was very small that this might take place. And fortunately for F and everybody involved, it didn't. The issue in the case became about whether or not a secondary bleed might occur following the accident. And the clinical evidence, which was agreed between the treating consultant and the expert that was instructed, was that within that secondary bleed might take place within a week or 10 days of the accident. So despite F presenting as very well in hospital, there was still this risk of a secondary bleed, which could be catastrophic. The evidence, which again was undisputed, was that if a secondary bleed occurred, there were a number of treatment options, including radiology, the insertion of a coil embolism to stop the bleed, and the removal of the spleen altogether. The concern from the clinical perspective was that if there was a secondary bleed, and if steps had to be taken to operate on F, for example, to remove his spleen when everything else had been tried, there would most likely have to be a blood transfusion or the use of blood products to save his life, because there was likely to be a significant loss of blood. And F was absolutely categorically clear that on account of his religious beliefs, he would object to the use of any blood products or any blood transfusion. He was very, very clear that that is something that he would not accept under any circumstances, including if the medics proposed to treat him in an emergency to save his life. He was supported on the ward by his parents, who were also identified as Jehovah's Witnesses and were very, very clear that they supported his decision, and they agreed with his view that he should object to or refuse any blood products. There were no concerns about his capacity. There were several conversations with him that took place on the ward from his treating consultants, a nurse on the ward, a paediatrician at one point, all took the same view that he had capacity. He was almost 18 and he had capacity. The concern from the medic's perspective was that if that situation materialized, i.e. there was a secondary bleed and treatment was required and the use of blood products were required to save his life, they would have to take that as a capacitous decision and not treat. And because of his age, and because he hadn't quite yet reached maturity, the age of 18, they weren't willing to accept that decision and not treat, and they wanted the court to intervene. So it was on that basis that an out-of-hours application was made. It came before Mrs. Justice Arbuthnot at 8:30 on the 6th of September. I represented the trust at that hearing. F wasn't present at the hearing, but he was represented. And there was argument about whether or not the hearing or the application should be determined that night. The application was for declarations that acknowledged that he had capacity, that he was competent to refuse the treatment, but that notwithstanding his objection, it was lawful and in his best interest to provide blood products or a blood transfusion in the event of an emergency. So the clinicians were clear that they only wanted to use blood products if it meant that without doing so, he might lose his life. For reasons I'll come on to a little bit later in this talk, when we talk about what's termed in a common law sense as emergency powers, I'll discuss what happened that night in relation to the court's assessment of whether or not this needed to be dealt with overnight. But in short, there was agreement, a reluctant agreement, that he could be treated conservatively overnight with a substantive hearing on the 7th of September, the next day, because the risk of a primary bleed was reducing. And there was agreement between the treating clinician and the very quickly instructed expert that the current risk of a second hemorrhage at the point that the court considered the application was less than 10%. So when the application came before Mrs. Justice Judd for a substantive hearing, the court heard evidence from the treating clinician, from an expert, Mr. C, from F himself, and from F's parents. And the evidence was slightly unusual in that the medics were largely agreed that he was clinically stable at the time that the court made the decision. He was in the window of risk for a secondary hemorrhage. The window of risk in terms of a primary hemorrhage had gone. It was only concerned now about a secondary hemorrhage, but that was decreasing every day. And the risk of a secondary hemorrhage was about 10%. So when thinking about that in the context of what that means in terms of treatment, there was a 10% approximate risk of a secondary hemorrhage taking place. And then beyond that, there was a risk that there may have to be blood products used in the event that he may lose his life. So it's a pretty remote chance that this risk would materialise, but if it did materialise, it would have been very serious. And his consultant, treating consultant, described a secondary hemorrhage as it could have been anything from a small rebleed, as in it could have been treated conservatively, there would have been no need for surgery or blood products, or it could have been a really catastrophic hemorrhage at an alarming rate. And the evidence before Mrs. Justice Judd, that again was undisputed, was that if that were to happen, he would need to go into the operating theatre within 30 to 60 minutes. It would all happen very quickly. The court, the hearing took about 3 hours. The court, as I say, heard detailed evidence on the relatively discrete point, and then gave judgment and made the order sought and declared that it was lawful and in F's best interests for the blood products to be provided in the event of an emergency arising from the injury. So it's very specific about the circumstances in which it could be used, but provided that, and this was a very important caveat that the judge imposed, that all other reasonable treatment options had been considered. And if any of you have had a chance to read the judgment, that is because of the weight that the judge attached to F's very strong view that he did not want blood products. So this had to be an absolute last resort. And again, the chances of it being needed were remote, but if that situation materialised, the risk of not providing blood in that scenario could have cost him his life, which the court said ultimately tipped the balance in favour of making the orders. Both decisions were appealed. My case, so the case I was involved in, came slightly after Arianna. So Arianna, the application made for permission to appeal in the case that Arianna and Victoria Butler-Cole appeared in had already been made. But essentially, both decisions were appealed on very similar grounds. And the Court of Appeal administratively on the papers, Lord Justice Jackson, made a decision that permission would be granted in relation to the following grounds. So in E's case, that the court was wrong to make an order permitting the use of blood products in the circumstances of the case. And there was real focus and forceful argument about the fact that where the risk, and Arianna will come on to this, but where the risk is so remote, it was inappropriate to make the order. And that the court's declaration that the appellant lacked capacity was legally flawed, which was accepted by the time that came to the Court of Appeal. It was a drafting in the order, but in terms of the substance, there was agreement between the parties that E was capacitous. In F's case, similarly, it was that the court applied the wrong legal approach to the circumstances of the case. It was argued that there should be a presumption or a strong predilection in favour of what F wanted, and the court didn't pay enough regard to that, and that the court was wrong to make an order permitting the use of blood products on the facts of the case. And again, the argument in relation to that was because the risk was so remote that the court shouldn't have made the order. In both appeals, the court refused permission to appeal in relation to a ground that was pursued in both appeals. And that was that a capacitous minor has the exclusive right to decide his or her medical treatment. The Court of Appeal referred to the previous arguments that have been pursued in cases that are similar to this, and said that it was a reiteration of the arguments advanced in Re-Ex number 2, the very well-known decision of Sir James Mumby, and the decision in Teaching Hospitals NHS Trust in DV, where again, it was argued that the court doesn't have the power to override the capacitous decision-making of 16 and 17-year-olds. And the court was clear that that has been unsuccessfully argued to date and permission wasn't granted. Despite permission not being granted, the Court of Appeal did address that in the judgment helpfully, and really reiterates and establishes as clearly as can possibly be stated that that power does exist. The case was listed for a full day in the Court of Appeal, where the court heard the two appeals that had been joined, but of course dealt with them completely separately, and dealt with the case of E and then the case of F. But both appeals were dismissed, and the court established and confirmed the following: that the inherent jurisdiction of the High Court is available in all cases concerning minors, namely persons under the age of 18. That has always been so, and any change must be a matter for Parliament. So whilst that might seem slightly obvious, it's such an important statement of principle, because a lot of these decisions were first instance decisions. And it was being, as you will see from the previous attempts to seek permission to appeal, it was being repeatedly argued that actually that was an inappropriate use of the inherent jurisdiction. And that because a capacitous 16 or 17-year-old would be considered capacitous, for example, under the Mental Capacity Act, that then their decision-making should be determinative. But the court was absolutely clear that the law as stated in Re W and the authorities that have followed remain good law. And that in circumstances of this nature, so looking at the facts of E and the facts of F, where you have a young person, particularly on the facts of F, who is very, very nearly about to be 18, the court still does have that power to override their wishes. Or, as the Court of Appeal made clear, to override their decision. Because what the Court of Appeal said is that it's really important to distinguish that where you have a young person that is capacitous or Gillick competent or competent, it isn't necessarily their wishes, it's their decision that the court's overriding. And that's an important distinction for a number of reasons, but mainly because if the court did not intervene, that is a genuine and legitimate treatment decision that the clinicians would act on. And that's such an important distinction, because it's not something that the clinicians will take into account when deciding whether or not to treat. It's a treatment decision. But the court was clear that it can override in those circumstances, in circumstances where the person is under 18. The court went on to say that the inherent jurisdiction is a protective power, and one of the court's central concerns will be to identify the risk in question. And here is where the court really grapples with the point about whether or not the risks are remote. So anyone that's read the judgment will see that much was made of the fact that in both cases, the risk of the treatment being required was very remote. But the court says, again, there's a really important distinction to be drawn between the risk of something and then the risk from the event occurring. So in this scenario, in F's case, the risk of him needing this treatment was below 10%. There's no dispute about that. But if the risk materialized, if that circumstance materialized, if he had a secondary bleed, a primary bleed or a secondary bleed, needed surgery and treatment, the risks associated with that were so grave that the court must weigh that in the balance. And the court was really clear that that's an important distinction and dismissed any argument that actually what the court has to consider is this risk actually going to materialize? The court said that the capacitous decision of a young person under 18 is not determinative, as was argued despite permission being refused, that there was a real focus at the hearing in the Court of Appeal that the court should take the decision of a capacitous young person, particularly a 16 or 17-year-old. The court said it isn't, that's not correct. That the decision of a 16 or 17-year-old is not determinative and is not the decision maker in law. And concluded by saying that if a proper evaluation of the minor's welfare is properly carried out, so as to arrive at a sound welfare decision, the court will not be acting incompatibly with the European Convention on Human Rights. And what the court was very clear about was that the question here really isn't whether or not the power exists. The court undoubtedly has the power until or unless Parliament says otherwise, to override the decision-making of a capacitous young person. The question is about how that power is exercised. And the court really drilled down into and focused on how did both of the judges in the family division at first instance exercise that power. Having established that the power exists, how was it exercised? Were there any errors in how that was exercised? And I'll hand over to Arianna, who will take us through the judgment in E. If I could just very quickly clarify at this stage, we've clarified the decision of the Court of Appeal, that there is a pending application for permission to appeal to the Supreme Court in both E's case and F's case. So whilst, of course, the judgment of the Court of Appeal stands, it's just worth noting that application is pending.
So in considering all of those findings in E's case, the court considered that the real task for the court was to direct itself to what they refer to as the transcendent factors of the child's autonomy and the preservation of life. It was argued in respect of E's case that there should be some sort of threshold test, and where the risk of her developing a bleed of some kind was quite low and was agreed to be somewhere around 1 in 1,000 to 1 in 2,000, likely closer to 1 in 2,000, that was an acceptable risk for her to take, and it wasn't a situation in which the court should become involved in its inherent jurisdiction. However, as Francesca was noting, the court differentiated between the risk of something, a low risk of something occurring, and the seriousness of that risk if it were to occur. Now, the reality is that the order that had been made in the case only authorized her wishes to be overcome in the event that she was suffering some sort of serious bleed, that she had had significant blood loss. And the trust had offered a recording that it would do everything within its power to avoid transfusing her if that was possible and seek to manage conservatively if it could. But in the scenario in which there was nothing that could be done to treat her except by means of blood products, that was where the power of the court had actually been given to override her refusal of that treatment and to treat in that manner. And in looking at the analysis of Mrs. Justice Thies, this was a short hearing, this was an urgent hearing, but it was apparent that Mrs. Justice Thies had treated E's wishes as being of considerable importance. The judgment had acknowledged the low probability of a serious injury occurring, and there was no criticism from the Court of Appeal of E's participation, which happened on a very tight timetable. However, as mentioned, she did attend remotely. She was supported by her father. Kafkas did attend as well and assist in putting her views before the court. So there was no lack of clarity as to what she wanted, what the decision she had taken for herself was, how important this was to her, and how much this was an issue of her own faith. And Mrs. Justice Thies had taken all of that into the balance, but had ultimately weighed up that in the limited circumstance in which she was facing a really serious bleed, which might put her at risk of serious injury or death, that was a scenario in which the balance fell in favor of preserving her life and her health rather than in preserving her autonomy in that case. The Court of Appeal didn't accept that the order made in E's case was unnecessary in convention terms, because if a crisis had arisen, it might have been necessary to save her life. The Court of Appeal found that the first instance court was certainly not wrong to make the order it did under the circumstances. It rejected the suggestion put on behalf of E that there should be a starting point of E's wishes taking priority over any other factors. And it was really just a matter of balancing these two transcendent factors, which it found that in this scenario, the court had done appropriately and had directed itself appropriately in the case. Francesca's just going to tell you how the judgment applied in F's case.
as I said a little earlier, the real question before the Court of Appeal was whether or not the power to override F's decision-making existed. It was how that power should be used. And the court really looked at how the judge approached it. The Court of Appeal was satisfied that the evidence of urgency justified the making of an immediate order. It had been argued that the case should be adjourned, there should be further expert evidence, and the court was satisfied that, having heard from the medics, that actually, if the risk materialised, as remote as it may be, there could have been a window of only 30 to 60 minutes. So the Court of Appeal was satisfied that the judge was right to make a decision and to not delay matters. What the Court of Appeal did say, however, that we'll come on to shortly, is that if that window had been longer, essentially, that it might have been appropriate for the judge to adjourn before making the decision, because at the evidence before the court at first instance was that if the risk materialised, treatment might be required within 30 to 60 minutes. The Court of Appeal said that, of course, is necessary to make a decision then. But if, even though the treatment might have been foreseen, if that risk window was longer, and it was longer in Arianna's case, for example, or in lots of other different treatment scenarios, then the judge might have considered putting it off essentially until it was urgent and needed to be made. The Court of Appeal said that the substance of the decision fully engaged with the two factors that lay at the heart of the matter, so the sanctity of life and his clear decision-making. The judge very carefully considered his feelings and his beliefs and the significance of this. And again, anyone who's had a chance to look at the judgment, the Court of Appeal set out, they actually quote from Mrs. Justice's judgment, where she details very carefully just how important to F this issue was and how he would consider this a real burden to carry. Because what he said was very, very, in a very compelling way, was that even if the court made the order, and even if the order wasn't required, such that the bleed never occurred and the blood was never needed, it would still be a huge weight on his shoulders to carry, to know that that order was made. But what the Court of Appeal said was that at first instance, that was properly considered and properly weighed in the balance. And ultimately, what tipped the balance was this very significant risk to F if that risk materialised. And because of his approaching 18th birthday, the judge wasn't willing to take that risk in circumstances where he may otherwise live a completely happy and healthy life. And similarly to in E's case, the Court of Appeal said that the decision was entirely one that the judge was entitled to reach, and it just cannot be characterised as having been wrong. I think what we're going to turn to now is emergency powers and emergency treatment, because this issue comes up routinely in these sorts of cases, and certainly came up in both of these cases, but in different contexts. So I'll hand back to Arianna.
So I start off by noting that this was not a point that was argued in tremendous detail before the Court of Appeal. It was argued in the skeleton arguments filed on behalf of both E and F, that an alternative option to making the applications that was made in these cases was that the doctors could have treated E and F without their consent in the event that there was an emergency. And it was argued on that basis that the order was unnecessary in all of the circumstances. Now, the Court of Appeal acknowledges that this is obiter dicta. This was not a point which was fully argued. However, it did make some comments that I think are useful and do bear some further considerations as a point of practice as to when applications may or may not be necessary, particularly when you're looking at anticipatory declarations or contingent declarations, as both of these were in these cases. The finding of the Court of Appeal, I'll put on the screen, doctors undoubtedly have a power and may have a duty to act in an emergency to save life or prevent serious harm where a patient lacks capacity or cannot express a view, for example, because of unconsciousness. However, we very much doubt that such a power exists in respect of treatment that has been foreseen and refused by a capacitous patient. It is doubtful whether such circumstances can properly be described as an emergency. Just go to the next slide. This was a point that we had considered on behalf of the trust, and it was a point that had been considered on behalf of F as well. And this is a point that has echoed through case law for over 30 years. And there does seem to be quite a consensus that this would not be a scenario that could be rightly considered an emergency in either E or F's case. Now, the starting point in all of this is to think about Montgomery and Lanarkshire. Both of these children were capacitous children. They were making their own decisions. They were 16 and 17 years old. There was no question of their lacking capacity. For children of E and F's faith, it would certainly be relevant and necessary under Montgomery and Lanarkshire to put to them the possibility of needing a blood transfusion, even if that risk were a very small one. This would clearly be something that would be of tremendous importance to them, even if it was only a 1 in 1,000 risk, a 1 in 2,000, to be honest, a 1 in 10,000 risk would probably still be worth putting to a child of the Jehovah's Witness faith because of the tremendous importance to them. Now, in considering past case law, including the Gillick case and Nottinghamshire case, the definition of an emergency depends on whether it is possible to make an application to the court. In another decision of the then Mr. Justice Mumby, G and Nottingham City Council considered the emergency scenario, and he considered that in an emergency in which there is no time to make even an urgent application to the court, it is lawful for medical professionals to treat a child in their care in their best interest to prevent harm. He gave an example of saying, for instance, medical intervention might be required in order to preserve the child's life or to protect a child from irreversible harm in circumstances of such urgency that there is not even time to make an urgent telephone application to a judge. In such a situation of emergency, a doctor can act without parental or judicial consent, and if the parents are acting unreasonably or contrary to the child's best interests, even despite a parental refusal of consent. He went on to state that doctors, midwives, and nurses do not have to stand idly by waiting for a court order if, for example, a premature baby desperately needs to be put in a special unit or placed on a ventilator. They are, of course, entitled to separate the child from the mother if medical necessity dictates and even if she objects. Law, medical ethics, and common sense march hand in hand. Now, interestingly, this was also a point that was picked up in Gillick, though very briefly in that case. And it was noting there that any doctor who advises a girl under 16 as to contraceptive steps to be taken or affords contraceptive or abortion treatment to such a girl without the knowledge and consent of the parents, save in an emergency, which would render consent in any event unnecessary, infringes the legal rights of the parent or guardian. Save in an emergency, his proper course is to seek parental consent or apply to the court. So again, going back all the way to Gillick, there is this line clarifying that the emergency power exists, but again, it runs hand in hand with the time that's needed in order to make an application to the court. The same view was echoed by the European Court of Human Rights in the case of Glass in the United Kingdom. Where an issue had presented itself, the treating clinicians should not rely on their emergency powers. And this was a case that concerned a dispute as to whether relevant treatment, which had been administered despite the refusal of the child's mother and without a court order, had been undertaken rightly as emergency treatment. The Strasbourg court was not satisfied that it had been. And what they noted particularly was that it had not been explained to the court's satisfaction why the trust hadn't made an application to seek the intervention of the High Court where the problem had presented itself, and that the onus was on the trust to take the initiative and to diffuse the situation in anticipation of a further emergency, rather than to wait for that emergency to present itself. And it found in that case that, having regard to all the circumstances of the case, the decision of the health authorities to override the mother's objection to the proposed treatment in the absence of authorization by the court resulted in a breach of Article 8 of the Convention. So again, a situation in which the doctors had sought to rely on their emergency powers, but where it was clear to them that there was a valid lack of refusal to that, and there had been no application to the court, there was an Article 8 breach in that case. Now, what I would propose on the basis of that case law is that the scope of the authority of a treating clinician to treat a child without the capacity consent of the child, or if the circumstance arose, the child's parent, is contingent on there being insufficient time to make an urgent application to the court to override that refusal. If an emergency situation is foreseeable and it is possible to do so safely, treating clinicians should take the initiative to resolve the situation rather than relying on emergency powers. Now, I'd again note the fairly tight timetables in both of these cases, but again, particularly in E's case, This case was heard in less than 2 hours from start to finish. This was heard very, very quickly while E was waiting for surgery in a hospital on a ward, and her surgery proceeded approximately an hour after judgment was handed down in the case. So in considering the application of this on, if I could just get the next slide. Apologies. I could just get the next slide onto E's case. In considering this in relation, sorry, I think we may be having slight technical difficulty. In relation to how this would apply in E's case herself, there was a very remote risk that she would actually come to need blood in any circumstances, and that was acknowledged throughout the application. However, it was not an unforeseeable risk that she might come to need blood. She had very clearly told the treating doctors that she did not consent. She had gone so far as to prepare her own written statement, refusing blood under any circumstances, even if that led to her death. Under those circumstances, this would not seem to be a case in which it would be appropriate for doctors simply to rely on their emergency powers. And if they were to treat her in the absence of her consent, it would really not be clear what authority they had to do that in the event that that emergency had arisen. So if I could just ask for the next slide. Sorry, again, I think our PowerPoint may have frozen on this, but I think the short version on this is what was contingent in this case, and I think one of the points of practice, while this did not form part of the decision of the Court of Appeal in this case, was that there had actually been a clinical decision that had been taken by the doctors as to how long they could safely wait. The competing consideration which had arisen in E's case was the fact that the condition that she had of appendicitis was itself causing risk to her. And while the longer she waited for the judgment to be handed down from the court, that risk was slowly increasing over time. Now, she was in a stable condition. She was in a hospital. She was being closely monitored. And there was a clinical decision taken under all the circumstances that it was safe for her to wait for that judgment until 5 o'clock that day. And in reality, her surgery had already started by the time that happened. But what I would put forward on this is a practice point is that there is that clear clinical decision and clinical judgment as to whether or not she was safe to wait under the circumstances, whether or not the application could be made without causing further harm to E under all the circumstances, particularly where the presenting risk of her condition was a source of risk, and the risk of her having a bleed was a relatively remote risk, that the weighing up happened appropriately in that case. So in this case, it's not clear that there would have actually been an emergency power, but that's all within the general framework of how long it was actually safe to wait to get an order from the court. And in this case, it was safe to wait. She was stable, and there was no evidence that any harm had come to her. So Francesca is just going to speak briefly about how this applied in F's case and the question of emergency powers arising, because I believe that was also argued at first instance in F's case.
Thank you. Yes, in F's case, as I touched on earlier, the first hearing was an out-of-hours application the night before the substantive hearing. And when it came before Mrs. Justice Arbuthnot, she adjourned the case overnight on the basis that both clinicians, so the treating clinician and the expert that had been instructed at very short notice, agreed that there was a very low risk overnight of a hemorrhage materialising and treatment being required. The point being really that by that point, the primary hemorrhage risk had reduced, and they were now into the window of a secondary hemorrhage. What was slightly unusual was that it was argued very strongly on behalf of F that the substantive application was going to be opposed, and that the substantive application should be adjourned so that F could properly respond to it. And that overnight, in the event that there was a bleed, and in the event that the risk materialised such that treatment was required and potentially a blood transfusion or blood products were required, it was argued on his behalf that the trust and the clinicians could use their emergency powers to treat him in that scenario, essentially because an emergency had arisen. The trust was clear, both at first instance and before the Court of Appeal, in a similar way that Arianna describes, that wouldn't necessarily have been a proper use of what are known as the common law emergency powers. And part of the reason for that was that this was an emergency that was entirely anticipated, and that the clinicians knew there was a risk that that would materialise and that they may need to treat. So it was difficult to see, therefore, when you look at the previous authorities, how it would have been appropriate in those circumstances to treat against the decision-making of F in circumstances where undoubtedly there was time to go to court. What there wouldn't have been time to do was time to go to court in the event of a bleed, because the clinical evidence was that if a primary or secondary bleed occurred, and if it was potentially catastrophic, then surgery would need to be performed within between 30 and 60 minutes. So whilst that would be a genuine emergency, it was foreseeable. And in that moment, there wouldn't have been time to apply to court. Now, again, as Arianna says, this wasn't argued substantively before the Court of Appeal. So they potentially maybe reluctantly said they couldn't delve into it. But what they did say very clearly on the facts of F's case was that they, in the quote that Arianna referred you to, that they don't really see how that would have been a true emergency, because it was foreseen, it was foreseeable, it had been foreseen. The clinicians were clear that it might need to happen, that treatment might be required. So I think it's helpful in the context of these sorts of applications to look at what the Court of Appeal said about that, because yes, you could argue that that's a genuine emergency, but actually when you look at it objectively, so say hypothetically for a moment that the application hadn't been made and that this was being looked at with the benefit of hindsight and that treatment was provided in that moment, and F himself wanted to look at that and potentially take action against any health trust that treated him, it would be very difficult to establish or to demonstrate that that was a true emergency and that the clinicians acted in a true emergency where they did not have the opportunity to seek the intervention of the court as they properly should. And the Court of Appeal agreed that it was urgent in the sense that if the situation arose, then there wouldn't have been time to go to court, such that the court was right to make the decision despite the remote chance, and the clinicians were right to take the view that it wouldn't have been appropriate to treat in an emergency when there was that clear and strong objection and there was an opportunity to make an application to court. Just before we turn then to any questions, in terms of practice points, the Court of Appeal, I think quite helpfully set out the approach to be taken to cases of this nature. And it may seem relatively straightforward, but it's quite easy to get lost in either the medical evidence or whether or not it's urgent or whether or not emergency powers exist. But the Court of Appeal said this. It said that when the court is being asked to exercise its inherent jurisdiction, there are 3 stages for the court. The first is to establish the facts, which again, in these cases, both judges at first instance did that. The second is to decide whether it's necessary to intervene. And again, that took place here because there was that clear analysis as to the fact that despite the remoteness of the risks in the event that those circumstances materialised were such that it was necessary for the court to intervene. And then the final and decisive stage is the welfare assessment. And just pausing briefly about the second stage, which is to decide whether it's necessary to intervene. There are, of course, there are cases and instances where the court won't necessarily intervene. And there's the well-known Mostyn decision where there was a dispute about whether or not a 16-year-old had capacity to agree to a termination of her pregnancy. And the Court of Appeal look at that decision and say, you know, it might, of course, it's improbable that any judge would have then taken the decision to override that view. The issue in that case was whether or not the person had capacity. It wasn't whether or not the court needed to intervene. And the sorts of cases we're talking about are cases where clinicians want the court to take the decision as to whether or not the treatment is in the person's best interests. And in those cases, I think it's a helpful guide to follow those 3 stages. So with one eye to the time, We have a few minutes left if there are any questions. Arianna, I don't know if you were about.
Yeah, we've got a few. I've just been able to look at those in the last few minutes. So there's one question we just have that picks up on some of the emergency powers points, which is that if someone needs their spleen out within 60 minutes, concomitantly with no time to get an application before the court, is there a line to be drawn between a medical emergency and an emergency power if it has been foreseen that the spleen needs to come out? Are we saying it is the foreseeable nature of the spleen needing to come out that feeds the clinicians potentially acting in breach of their power and duty? Now, I mean, what I would say on the basis of Gillick and Glass and the G case is that the definition of this power to act without consent does very much depend on the circumstances that there is no time available to go to the court. And that's what comes up again and again in the case law of saying that where there is no time to do that, where there is no time to override the person's consent, it's not incumbent upon the doctors to just sit there and watch a person to come to serious and avoidable harm under those circumstances. But I think what the Glass point is really making is the need to try to foresee these things ahead of time. And if there is a situation in which a person has refused treatment that it is considered that they will require and that consent should be overwritten, there should be an opportunity to take that into court rather than simply relying on the emergency powers in that case.
Thanks, Arianna. If I take another question, was there a discussion about whether the capacitous young person who agreed with their parents was in fact under undue influence from their parents? I think that's a really important question. That didn't arise in this case, thankfully, certainly not in F's case. His parents, yes, were very involved, but the discussions that took place with F were very much, firstly, on his own without the clinicians, and there were absolutely no concerns about the influence of the parents. In fact, the parents were relatively quiet about the proposal, such that they said they respected his views. And it was only when they were directly asked by the judge to explain their views that they then went into detail. They were very clear that they just respected their son's views. And it was only when they were really pushed and asked. But absolutely, I think that issue is something that needs to be considered in these sorts of cases, and I'm sure often is, but it didn't arise here. And then, Arianna, just before I hand over to you, just one question that I think I can answer very quickly is, in terms of how these sorts of cases are funded and how are the respondents funded? Are they public or private? Arianna, in relation to your case, I'm not too sure about the answer. I know that in relation to my case, the legal representation for F was privately funded. Was that the case in E?
Well, I was probably worth noting, there were the same legal representatives in both cases acting on behalf of the young people, and it was very much presented as a united front. I'm not aware of the specific funding in E. She wasn't represented in the first instance. She acted on her own, but she had the same representative as F in the Court of Appeal. I think just picking up on some of the other questions, one could probably answer relatively briefly. There's a question of, in effect, were E and F trying to make advanced decisions to refuse treatment, but this is not lawful until the age of 18. I think that's a very accurate statement, and the written statements that they had made certainly stood as extremely clear evidence of what they wanted in the case, and I think really put beyond doubt what their wishes were and what decisions they were taking for themselves. But this was actually a point that fed into the overall question of the powers under the inherent jurisdiction. And I think it is notable that despite the Mental Capacity Act generally having an application for people over the age of 16, Parliament had specifically not given the power to make advanced decision to use treatment for people who were 16 and 17 years of age. And you can only make that after turning 18 years of age. So again, I think it was certainly very important evidence. And I think it was certainly factored in E's case that we were aware that she had made this written statement, which set out very clearly what her views were. But it was not, in effect, a binding advanced decision to refuse treatment. And I think in many ways, I think that almost brought the question to the fore slightly more, because in the event, in E's case, had the emergency arisen, the nature of the emergency was such that it would have arisen extraordinarily suddenly within a matter of seconds or minutes. If she was suffering from a severe hemorrhage, she would have been most likely unconscious or in a state where she would not be able to appear and put her wishes to the court. So if the emergency had actually arisen, there would have been no opportunity whatsoever for that case to be brought before the court, because again, the clinicians would have had to act instantly. So the only way that we could bring that before the court, and where it was a potentially foreseeable risk, was to do that ahead of time. And I think a follow-up question for that, if a Jehovah's Witness is over the age of 18, would their wishes in advanced treatment wishes be respected, or would there be a court order to give emergency treatment? Now, if a person over the age of 18 had made a valid advanced decision to refuse treatment, that would stand, whether or not they were awake or unconscious or unable to give that decision at any point in time. But I'm not, the answer is essentially yes, it would stand if this was a person who had capacity or had made a valid advanced decision to refuse treatment and then had subsequently lost capacity. I think, Francesca, were you about to come in on that as well?
No, I agree with your answer on that. There's a question, has discussion been had re the need for blood products for the child who is a Jehovah's Witness in case of emergency in the future, and what was the outcome? Just in relation to that, there have been cases that consider the need for ongoing treatment. So, for example, where you don't just have an accident or an injury that needs treatment, but there are, I've certainly been involved in cases, for example, where there may be a Jehovah's Witness child that has a diagnosis such as sickle cell syndrome and will undoubtedly need future treatment. And there have been applications whereby essentially future authorization is sought, so that it's not just constantly acting on emergency powers, because again, whilst there can't be specificity about whether or not an emergency is foreseen, there is a real likelihood that there would be a need to treat in the future. So I know that there are cases relatively routinely about whether or not future treatment can be provided to a Jehovah's Witness child. Just looking through the questions remain.
I think one other just talks briefly about the decisions of the parent versus the child, and just asking, this and other recent decisions indicate to me that it would be at least inadvisable to rely upon parental consent in the face of capacitous refusal of a young person. But I'm not aware of any recent cases addressing this point directly. I think in these cases, both of the cases, there was no division within the family as to what the course should be. The E was making her own decision in this case, in which she was supported by her family. My understanding is, again, F had made his own decision, but there was certainly no objection on the part of his family to the decision that he had taken. In both of these cases, these were young people with capacity. They were 16 and 17 years of age. They had capacity. They had made their own decision. I would agree. I would not be looking to the parents to override that capacitous decision in these circumstances.
I'm conscious of the time. I think we're at the end of the seminar. To any questions that we haven't got chance to answer, I know that our brilliant marketing team can send them all to us. So if we get the opportunity, we will try and respond to them. But thank you, everybody, for joining in tonight. There was a great number of you that turned out, and we appreciate it. And we hope that this has been helpful. So thank you, everyone.
Thanks very much.